I'm meeting with Gayle Anthony, who is both a lawyer and a mediator. And so before we go any further, would you please give them your contact information to be useful to give your full name to, and for anyone that would like to reach you, just do that first.
Okay. Gayle Anthony. My firm's name is Gayle Anthony, Attorney at Law, PLLC. You can reach me via email at ganthonylaw@aol.com, or you can reach me at the office at 801-676-7743.
Thanks. Well, we don't script these, as I've explained to you, but I did tell you a little bit about what you might want to share with people about how you got involved. So you are a lawyer.
I am a lawyer.
And were you a lawyer first, or were you a mediator first?
I've been a lawyer for 25 years.
Okay. And how long have you been mediating?
Oh, probably 3.
Okay. What got you interested in mediation?
You know, as a lawyer, especially graduating a quarter of a century ago, we were never taught mediation in law school. We were taught to go out and win the case, litigate the case, or whatever it was. Mediation probably became like a buzzword 10 years ago. I actually had 2 really important cases in my life. One that lasted for years and years, and we ended up settling both of those in mediation. I had no hopes of settling it in mediation. I thought it was a waste of time. But then I started to think about that, and when my son went to college, I decided to, I had more time to kind of branch out into that. I've been arbitrating for FINRA for a decade, so I've been around arbitration.
And what's FINRA?
Financial security. So anybody dealing with brokerage houses with their account and why they lost $2 million and that type of stuff. But arbitration is way different than mediation.
For those that aren't familiar, because there are people that will confuse the terms, people will call up and say, are we going to go to arbitration? Like, well, no, but I think I know what you mean. So
yes.
For the sake of those who aren't familiar with the distinctions, why don't you do that for them?
So arbitration is binding on the parties. They agree to it, whether it's through a contract or the parties come together, and it's usually written in a contract before there's ever a controversy that we'll settle this by arbitration. So you pick a mediator or a panel of mediators, and the decision is binding on you and appealable.
It's like private court,
yes.
In other words, because what you'd be doing is subjecting the dispute to being decided not by a judge, but by an arbitrator,
exactly.
Like Gayle over here, who would say, you're letting me decide the case, and then I will send my decision to the court saying this was resolved in arbitration, this is now binding, and then the court will then issue a judgment based upon that arbitration.
Well, and a lot of times the court would never even see it. If there was an appeal, it's very difficult to appeal an arbitration agreement.
Right. Now you can arbitrate family law cases. It's extraordinarily rare in Utah. It may get some traction, but we're talking about mediation, which is where you come in and try to help the parties reach an agreement, but don't tell them what to do and cannot impose your decisions on them.
I am completely neutral. I normally start with everybody in the same room unless there's some protective order or that type of thing. I do mediation in business law. I do mediation usually post-judgment for divorced couples. That maybe it may not be as inflamed, but even a business arrangement that's gone bad is like a divorce. And most people are in the same room to start with. We may break off, particularly if one party has a preference to do that or is feeling threatened.
Why do people, let's assume that they're not feeling threatened, like I'm going to kill you because you won't make a deal with me or do my will. Why do people split into 2 different rooms and then have the mediator go back and forth? Because again, we are accustomed to that, but for somebody going to mediation for the first time, it strikes them as kind of weird. Let's demystify that.
Yeah, it shouldn't be a mystery. It should be actually more comforting to them. Maybe they'll speak more freely to me if the other person isn't there. But then if they tell me, you can't tell this to the other person, but that still gives me an idea of what their needs are. The first thing in a mediation for a mediator is to determine who needs what out of this. Obviously you have your issues, but what do you need from this? And that really kind of disarms people. And, what do I need? And they start thinking about what's your top priority here? What do you want to get out of this today? And it may end up that the other person's needs are totally different, and it's a very solvable situation.
And you raise an interesting point too that bears repeating, as we've talked about in other interviews, but Can what's discussed in mediation be brought up in court?
No, everything is confidential.
Yeah, so.
I can't talk, you can't talk, your attorney can't, everything's
If
confidential.
you and I are in
sign an
mediation
agreement.
and we're disputing and our mediators, I may say, well, it's true, I didn't shovel the walks that morning. I don't know if that's the reason why you fell down or not, but I don't think it was. You could not go into court and say, well, Eric admits that he didn't shovel his walks. I heard him say it in mediation.
Right, and I couldn't say that, and nobody in the room could say that.
Nobody else could. Well, why? I mean, why not allow that to come up in court?
You know, that gives you the option to say things that might encourage settlement. And if you're in different rooms, like, and he said, you know what, I totally spaced and I should have shoveled and I didn't. Well, that gives him the opportunity to say, well, okay, if that did come out in court, what would you be looking at? What is your worst case scenario? Versus these people only want their medical expenses paid. It's $1,500. You know, you kind of do a cost-benefit analysis for them. Maybe it's on a board or something that they can visualize. And they're like, you know, that's, yeah, okay, I authorize you to go, say, to the other room. How about $1,000, you know, no admittance of guilt or whatever. And I would never go back and say, yeah, he totally spaced and he should have shoveled out. You know, it's not me to make a judgment call. One way or another, I have to be neutral. But on the other side, you know, the other parties in the room, well, you know, he's offering you $1,000, but if you want to go to court, you're looking at 3 years, maybe an appeal. We could just walk out of here today and be done with it. Both parties go their separate way.
You raise an interesting point as I'm sitting here listening to you, and that is, oftentimes, if I am making the proposal to the opposing side, my enemy, then they will see it as, I wonder what he's got up his sleeve there. But if it comes from the mediator, it's like, well, this was a proposal that I've heard. Or we sat down together and thought of some ideas, and what do you think of this? Because you don't have a dog in the fight.
Exactly.
And you might say, well, I got to tell you, and some mediators feel this is appropriate, others don't. You might say, well, this sounded like an interesting proposal. I'm not saying you must do it. I'm not saying you're foolish if you don't. But coming from you, it might cause that person to say, well, coming from you, I don't immediately want to just react with anger or rejection.
Because they'll actually listen to a third party, whereas immediately, this is particularly true in post-judgment or even divorce, and I'm sure you're familiar with that. As soon as they see other people, they just tune them out. They're just enraged about everything that's happened.
You could say the same thing the mediator said and have a totally different response.
Exactly, and the analysis would be, if you have children, you can tell that teenager 1,500 times something that they should do, or it would improve them, whether it's in sports or whatever. And there's no cognitive recognition by them at all. If the coach says it, the child comes home and it's like altering their life. And so it's the same sort of thing. If you hear it from an independent party who, you know, by all accounts deals with this on a regular basis, has had, you know, a lot of business dealings, and frankly, I view divorces as a business gone bad. It's a partnership that went bad. There's a lot of emotions.
There's more to it than that, but that certainly is an element of it.
Yeah, I mean, when you cut down to the bottom thing, there's a lot of emotions. But I've had actually business dissolves that were family partnerships, and they were just as horrendous as any divorce. But if you listen to a third party, and not that they're going to tell you what to do, I would never say what to do, but I would say, so here's this offer. You know, again, what is it that you're needing? You're needing closure. You're needing to move on. What do you want to sit in court?
Or even something more tangible. Like you are starting college in Tennessee. You don't have time to hang around here and be going back and forth, or you've got to sell this by this date, or you've got to declare bankruptcy, and there's other things.
Well, and if you say, basically, you need to move on with your life, and what's the quickest way for you to do this with the least amount of loss, anguish, and whatever, and just be able to move on. You know, and a lot of times that's what people need to do. They need a closure, and they need to go do what they want to do.
Let's talk a little bit about what you think ideal mechanics are in a domestic relations or a divorce setting. How should people prepare? What do you think is the best way for you to help them?
You know, I sometimes will, a lot of times when people come before me, they're not represented by attorneys. They don't want attorneys, particularly if it's post-judgment, and they're, as you know, they're required to try to mediate their issue.
Yeah, if you're dealing with a child custody dispute or a parent time or visitation dispute, before you can go to court, you have to go to mediation. My personal opinion on that is that's a terrible law, but it is the law. So that's what Gayle's referring to.
Yes.
And so when people, let's talk about that then. Let's talk about somebody post-decree dealing with a custody or parent time dispute without a lawyer. How should they best prepare so that you can help them and maximize their time?
You know, I don't have them do a lot of prep. A lot of times kind of let them vent on each side. I usually ask if there is a problem. I choose a party, usually the party that brought the action or is going to bring the action. Usually let them go first, air it out, let the other person respond. You know, just kind of get a sense of where their emotions are. You know, sometimes it's not as big an issue as people think. And sometimes it's like very inflamed and there's been control issues or, you know, mother-in-law issues or whatever it is. So I finally get that. I don't ask them to do anything in preparation other than to think about what they might need or what they want, what their issues are going to be. And then I let each person go through their issues and we write them down. And that's the point I would decide, would we be better off separating for a little while and then coming back?
How long do you think people should take in both a custody or parent time dispute kind of situation as opposed to we are here to discuss every issue in our divorce or our paternity action or something like that?
You know, surprisingly, if you might have 5 issues in mediation if it's a divorce, you know, 5 big issues. That can actually go faster sometimes than a child custody dispute of I want them on Christmas Eve.
So that's an interest. I mean, in other words, don't think that one issue is shorter than 5, especially if those 5 issues are things where there's not a lot of disputing. It's just a matter of having to take care of it, crossing T's and dotting I's, but not fighting back and forth and taking positions.
Exactly. You know, who wants the lake house? I don't want the lake house. That, you know, that just reminds me of whatever. 401k, split it down the middle. But what alternate issues do is give you, one person might give on this, and I can say, you know, I'm not going to tell you to accept this, but he was pretty gracious on giving you the lake house or whatever it is. You know, he's pretty open to this. So in all fairness and in a good faith, is this a big issue for you? If it's not a big issue, then you can afford to be a little bit lenient on this. And maybe that's going to help fix the next issue if there's give and take. And honestly, once there's give and take on things, it's good. But if you just go in there and it's about a child custody and Christmas, you know there's only one day that's Christmas.
Yep.
You got to fight over Christmas Eve. Well, my mother's coming, and you got to fight about, and then it turns into, well, you didn't pick them up from daycare. So those are really the longest, hardest issues.
With that in mind, how long should any mediation, no matter what the issues are, in a domestic relations setting last before you feel as though you're reaching a point of diminishing returns?
I think if we've gone 4 hours and there's nothing, and it might even be quicker than 4 hours, but if we've gone 4 hours hoping to get somewhere, or the story was long, or you got them separated for a reason, and you know the mother-in-law is involved or something, which we try to keep, it's just the 2 parties in mediation, but every once in a while you have a wild card. And texting now is a big thing. You know, you don't want people texting the mother-in-law or the mother or the best friend. You want it just those people so they can focus on that, not what their friend said, their lawyer said, you know, or their neighbor said. But if we've gone a couple hours and there is no hope whatsoever, you know, I'll call it. You know, it's just not, you tried, you know, hopefully in good faith. I don't think there's anything at this point that I can do for you. Now, having said that, there might have been some movement, but people get fatigued. Why don't we table this and meet again in a week? So I actually had a recent case in a divorce, well, I call it a divorce, but it was a family partnership. And we were at it 3-4 hours, and we were all in the same room. And I actually said, these are the things to consider. They asked if they could continue it and go back and consider it. Ultimately, they canceled the next session and they ultimately settled on their own based on what we had laid for. So sometimes it takes going home, sitting back, sleeping on it, to say, you know what, I don't want to be in court for 3 years. I don't want to drag my kids through this.
I can see my way clear to a solution that maybe wasn't apparent at the time I started.
Yeah, I mean, it gives them maybe a different way of thinking. So even if you don't settle it that day, you may very well settle it. I had a child custody case with a child that was never raised by the mother, and actually either parent, and an aunt had raised this child, and all of a sudden they wanted it back. It was pretty clear they wanted this child back for aid purposes, not to actually take care of the child, and they were living in a very unstable situation. And we went nowhere for 3 hours on this. There was a lot of crying, there was a lot of accusations, and I said, I'm sorry, this isn't going to reach a resolution. And the aunt called me the next day and she said they signed all the parental rights over to her. So sometimes it just takes hearing a third person and what your best case scenario is, what your worst case scenario is if you don't want to settle, and thinking it over at night.
In fairness, they might have gone and done that on the courthouse steps, but that would have taken a lot longer to get there.
And a
who
lot more
knows-
money.
And a lot more money. Now, this is, again, some of these questions may seem kind of elementary, but how long are you required to go to mediation before you can quit if you're not getting anywhere?
Well, mediation has to be in good faith.
What's the legal requirement?
I don't think there's you have to sit there for 90 minutes.
There is not.
Yeah.
There is no requirement that you must meet for at least 30 minutes or 90 minutes or something
Yeah,
like that.
it is required that you should be there in good faith. You should be willing to listen. Can you make somebody listen? No.
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 Again, another stupid law that is really unenforceable because, and in fact, when you think about it, some of the collective bargaining laws are similar, where you must negotiate in good faith. It's like, but what is that?
Yeah,
I mean,
what if somebody
what if
doesn't want
What
to
if I really
negotiate?
feel as though you shouldn't get 15-minute breaks because you're sitting most of the time or you're in a climate-controlled area? And so, anyway, I digress on that, but it is important to know that you do not have to stay. And some people think, well, because of good faith, I guess I have to hang around for at least a couple hours or maybe I'll get in trouble. I don't think so. And you can give your opinion as well. But I think that if you showed up and just said, from the get-go, we could just tell that this wasn't going anywhere. We made a couple of things saying, there's a few things we really insist upon and we're not going to have, and we just couldn't get anywhere. Get up and leave. Save your money.
Yeah.
Yeah. Do you have?
It doesn't do anybody good to sit there if you're honestly not.
Yeah, just with
you're-
false hope.
Yeah, if you have your feet stuck in the cement, and that might not be a bad thing. Maybe you are dead right.
Yeah, maybe you'll win in trial. Maybe you can't convince them of that, so you just say, all right, well, I'm sure as hell not going to sell myself down the river, so I'll go to court. I don't want to. I don't want to spend the money and the time, but if you're not going to settle on fair terms, I'll go to court because I think I'm gonna win.
Yeah.
I think it's that cut and dried.
And sometimes that's the case. It's not a case for mediation. Not every case is a case for mediation. And I agree with you that having a law requiring you to jump into mediation first may or may not be that helpful for everybody.
Yeah, and yet that is what the law is. You can't go to trial until you've had a mediation, and it's interesting. Some people, I'm of the opinion that you should mediate as soon as reasonably possible to get as much benefit from settlement. Other people are like, well, I won't go to mediation until after discovery is over. I'm going, and discovery means that you're preparing for trial. It's like, well, what if we can settle without a trial?
And you're also incurring costs
what I
in
mean.
doc preparation, getting things.
Depositions and
Exactly.
temporary orders and all that sort of thing. So everybody can do things differently. My way doesn't always work, but I'm of the opinion that you should try to get to mediation as soon as reasonably possible. You may need some documentation and financial information to make an informed decision, but it irks me when hey, let's go to mediation. The opposing side said no, and then I file a motion and they'll say, we won't go to mediation until discovery is completed. And it's like, okay, well, it's not as though we're handling the huntsman's divorce here.
Yeah, exactly.
This couple knows what their finances are, what their debt situation is. They know they have children. They know who takes care of them. what is it you need?
Well, and
But-
sometimes I will have, if there's attorneys involved and there is a particular document that's in question, I will have them give me that before the mediation.
So that you're familiar with it and it just gives you the context for what we're going to talk about.
And the other party, they may not have given that to the other party because
That's a
it
good
goes
point.
back to like two children arguing, well, I'm not going to give it to him, so they give it to their mom who gives it to them. You know, because it is, they have to have the information, but just because it's that spouse, they're not going to give it to them. Or maybe that spouse doesn't have a lawyer and didn't know to ask for it. So in all fairness, this is what they made last year. You've been separated a year. You know, his wages went up substantially, or his wages went down substantially, and now he has a disability claim or something.
Do you have a cancellation fee if people cancel, later than 24 hours in advance or something like that?
24, yeah, I do have for 24 hours, and cancel be 24 hours in advance.
So if I'm supposed to come see you at 3 o'clock and I call you at 9,
If you're rescheduling it,
No,
it's one thing.
I'm canceling.
You're canceling. I do have a 1 hour cancellation fee, and that's primarily because I could have put a mediation
Yeah.
in that spot.
Now that's gone. And how much is that?
175.
So you're $175 an hour?
Yeah, now if it's a hardship case, meaning that the people are getting divorced, they don't have a lot of money, may or may not have attorneys, I'm gonna work with that person, especially the single parent that has 4 children.
And for the sake of the archive and everything, this is $175 an hour as of October of 2014.
Correct.
That's right. So I want to make sure. So don't call her up if you're watching this 2 years later and say, you promised. Yeah. So you can do a sliding scale as well, depending upon
Yeah, I mean, if
certain needs.
it's, you know, I'm a soft heart. I mean, my mom was a single mom. I mean, I understand what it is, you know.
Well,
so-
I'm glad we had, because that's kind of interesting. That's one of those, so you know a little bit about what it's like in that regard as a child of a single parent. That's interesting.
Yeah, that's actually why I became a lawyer.
Oh, really?
Yeah, I was 14. I knew I was going to law school. So,
What, because your parents had a terrible divorce, or because your mom was a victim of the system, or everything, or?
yes. My mother had a degree from SMU, by all rights, a great school, but she was a teacher. She had stayed home with kids like most mothers did back then. It would have taken her 2 years to get recertified.
And she was imputed a teacher's salary from the get-go.
Well, yeah, that. But she was working at a bank for $3.50 an hour because she had to put food on the table. At the time, she had breast cancer as well. So it was not a great picture. My dad had some health problems.
So in fairness, I mean, do you have an axe to grind that would mean that you would favor women over men or anything like that?
No, because it could be the man in that situation as well. I mean, I've had.
And it doesn't sound like you have an agenda, set because your career didn't you didn't spend your whole career as a lawyer representing single mothers.
No. In fact, I don't do any divorce law anymore. I did the first 10 years of my career, and not because of that, but just because emotionally, these people, you need to understand emotionally what they're going through, what the family's going through. Dad's not making child support, which used to be the norm because dad was the one working. That's not true anymore. It could be mom not making the child support now. So to me, it's what's in the best interest of the children. You know, 9 times out of 10, it probably is the mom that has the kids still. You know, especially in Utah, quite frankly. I do practice in several states. I'm licensed in 4 of them, and soon to be 5, I hope. And you see different things in different parts of the country, but in Utah, primarily the women do have the children and may or may not be getting paid. And I've even had things where different families, they had found out they were living double lives, or they had different families.
Let me ask you this. Do you bring anything from other disciplines to the table that might be of help to certain kinds of people going through a divorce? I mean, it sounds like finance might be, or business, of a strong background in family businesses.
I was corporate counsel for subchapter S companies for 18 years.
So you'd be in a unique position to help understand family businesses, whether it be the wife is a 50% or a 49% shareholder in the husband's business, but she never really did anything that was set up for tax purposes or something. And so you could help with that. You could help with winding up. You could help with intergenerational stuff like that.
Yeah, and a lot of times it'll be a company, like maybe somebody's working with their dad, or they were given stock for financial planning from the parents' side. Now they're in a divorce, you know, but did they commingle that money, and what was the intent, that type of stuff. Do you really want to be involved in a company with your in-laws that you are not speaking to right now?
Well, I think that's very valuable, and you're the first I've spoken to in the chronological order of people, and so that's another thing you may want to consider is a lot of mediators have different backgrounds. Some of them in social work, some of them in business or in business law, some of them in counseling, some of them in teaching, some of them in international relations, and that all those things might come into play if you, especially if you have a spouse who's not a citizen or a spouse who's going to move back to Singapore or something like that. And so keep those things in mind. And I'm just very grateful. This is a great conversation. I mean, I know people watching this learned a lot. Thanks for being so crisp about your presentation as well.
Oh, well, thank you for having me.
Yeah. Before we go then, just give your name and contact information again for those that would like to utilize your services.
Yeah, Gayle Anthony. You can email me at ganthonylaw@aol.com or give me a call at the office at 801-676-7743. And I might add that we talked a little bit about me practicing in different states.
Okay.
That's a big thing today in divorces because companies are moving people. People are living in different states, might have property in different states.
So what states are those?
Illinois, Florida, Utah, and going for Texas right now.
All right. Thank you so much.
All right. Thank you.